Clarification of your lordship's order.
Ah.
My lord, one writ petition was filed, my lord, against performance of my Durga Puja in my own property, and that was came before your lordship by way of appeal. And your lordship passed the order. Now the appellant using your lordship's order and restrain me not to perform in my own puja. And my lord, from Saturday my puja to be start.
Be listed tomorrow.
My lord.
You have served notice.
My lord. Grateful, my lord.
My lord, it is an intra-court appeal. My urgency is the Honorable Single Judge had given deadline to preferring appeal by Monday, coming Monday. So that is lordship. If your
To
lordship,
give tomorrow we list. Yes.
My lord, this is a group 6 matter. I am praying for inclusion.
There are two intercourt appeal against the order of single judge, but that is there is a urgency in the matter. Let it appear in the list. Phillips India versus Assistant Commissioner of Income Tax, my lord.
The batch matter. Oh, Mr. Pardiwala will come.
Yes, my lord. Mr. Patriala. 18, my lord, he has given the date. Subject to lordship pressure, my lord.
We don't know 18th whether it will be possible.
25th.
All right, tentatively 25th we'll fix.
Yes, my lord.
We'll confirm it.
Yes, sir.
By next week.
My lord, item 14 and 20, my lord, kindly takes it up next week. My lord. Is my appeal.
There's item 1 to 6.
Which is it was.
So 1 to 6 we'll.
May have it on the 8th. Oh, 8. Item 14 and 20 next week, my lord.
14 and 20.
These two, my lord.
26.
Next week, my lord. Whichever.
No, item 14 and 20.
Item 14 and 20.
20.
Yes, my lord.
When it's called, you give a date.
My lord, may I permission for upgradation item number 37 of today's list.
Original side daily list item number 7 for admission tax matters. Original side daily list item number 7.
Please give the file. Probably they thought 1 to 6 will go on. Who will appear? Ritu Doria. The respondent? All right, pass over. Yes, she is come. Item 7. Who will appear for the appellant?
Lordship, Lordship, on last occasion it was Mr. Roy Chaudhary, if I'm not wrong, Mr. Prithu Dudoria and Mr. Roy Chaudhary, if I'm not wrong.
Not here. We will say pass over.
Lordship.
Mr. Bagh is appearing for you.
Lordship.
Item number 8.
What is this for?
My lord, this is my lord will recollect, my lord. This is the 263 matter, my lord, which my lord had heard. My lord, Mr. Tilak Mitra is appearing.
Where is he?
My lord, here what had happened is during the pendency of an appeal preferred against the order, they had invoked 263 proceedings. So the tribunal has gone on that it cannot be done. And my lord, that is covered by my lord's own judgment in the case of Renuka Philip. My lord, I had handed over a copy of that judgment on the last occasion.
Let us see the order of the tribunal. Where is it?
so Tilak Mitra was arguing that.
My lord, the findings will start at page 88.
80.
88.
89.
I'm appearing for the appellant. I'm for the appellant, my lord. Sorry, my lord.
না 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 ওখানে কি এর পরেও তো আছে 1.2 The relevant finding, my lord, may, my lord, start from page 99 of the tribunal, sir. Wherein, my lord, the tribunal had, my lord, gone on to deal with the aspect that because, my lord, the assessee was, my lord, found to have opened that much of the account, which actually he has actually, my lord, opposed. And then, my lord,
But then the case of the assessee was somebody impersonated him and opened a bank account.
yes, that is
That
the
aspect was not gone into by anybody.
But my lord, kindly see, my lord, one aspect of that particular,
Lord,
my
may-
lord, the contention, that was, my lord, that has been canvassed by the assessee once again and again. But, my lord, that has, apart from, my lord, contending that there are no other, my lord, material to show, neither any investigation was concluded. Nothing has, my lord, come out to, my lord, surface the fact that these accounts are not of the assessee.
My
So,
lord,
my lord, something have been found, my lord, has been credited in the account of the assessee, and it is, my lord, the primary owners, my lord, on the basis, on the lies on the assessee, my lord, to say,
He has issued,
mere denial, my lord,
no, he has issued 2 show cause notices.
my lord.
The tribunal finds that there is no discussion on any of the points raised in the reply.
Yes.
That is fatal.
That's the one aspect, my lord, I must be.
no point, my lord, if I may find out, if I may point out before my lords, my lord, what the tribunal did is it said that since that appeal is pending, you decide those issues there. And tribunal has only said that in this case, section 263 cannot be invoked. And my lord, subsequent to the ITAT order, the 147 order was passed by the officer that came in my favor. And my lord, they have not preferred any appeal against that order before the tribunal. So my lord, now the position is that they have also accepted the stand.
No,
My lord, on the last occasion, I had handed over a copy of that order.
that's right, my lord. My lord is now testing, my lord, the
My lord, that is the
my lord,
two-
the illegality or legality of the order passed under section 263. So, my lord, it
But
is
then thereafter there is a 147 proceedings which has attained a finality. All issues have been
yes, but my lord,
reopened.
that is the
I must indicate to your lordship, my lord, 263 proceeding, my lord, at that point of time that appeal was pending, my lord, that has never been pointed out to, my lord, the 263 authorities. Assessee, my lord, was aware of the fact, my lord, that appeal has been, my lord, taken out by him. That was pending, my lord, prior to, my lord, the conclusions of the 263 proceeding, my lord, tribunal, my lord, did not attain the finality. CIT appeal, my lord, was pending on the date, my lord, when 263 proceeding was concluded.
My lord,
And, my lord, there was not a, my lord, iota of evidence, my lord, brought by the assessee before, my lord, the commissioner to indicate that, my lord, the order has been assailed before, my lord, the commissioners have appeal.
my lord, may kindly have a look at page 28. My lord, we had annexed the copy of the appeal before the 263 proceedings. Page 28, my lord, point 7.
Next.
Has the tribunal noted that? Tribunal has not
My
noted.
lord, tribunal has not noted
Tribunal.
this. That question was never raised before the tribunal.
Page 28.
My lord, may I have a look at point 7? Also completely denying the said bank account belonged to him and that the Alex turnover was carried out by him, duly preferred appeal before the CIT on 28/10/2021. Copy of the appeal filed before the CIT is enclosed as Annexure 7 to the submission. And if the CIT was aware of the appeal.
No.
My lord, it was a part of my written submissions, the copies were.
And what happened to the appeal before CIT appeals?
My lord, subsequently, after passing of the order, ITAT order, they have decided in the assessee's favor.
That is attained finally.
That has attained finally, my lord. It's an order of 2024, October 2024. They have not gone before ITAT.
Yes, you have.
My lord,
Please come. This appeal by the revenue filed under section 260 cap A of the Income Tax Act 1961 within bracket the Act is directed against the order dated June 12, 2024, passed by the Income Tax Appellate Tribunal C Bench Kolkata within bracket Tribunal in ITA number 254/K1/2024 for the assessment year 2015-60. The revenue has raised the following substantial questions of law for consideration. Page number 5A and B. We have heard so and so. The short issue which falls for consideration is whether the learned tribunal was right in allowing the assessee's appeal and setting aside the orders passed by the commissioner under section 263 of the Act. The order passed by the learned tribunal is an elaborate order wherein all the factual issues have been thoroughly dealt with, apart from noting the legal position. The assessee's consistent case was that he had not opened any bank account, rather somebody else impersonated him, and by misusing his identity card, and he came to know of it when he received information from the sales tax authorities, Bureau of Investigation, commercial taxes. Though such a stand was pleaded before those agencies, none of the agencies has undertaken an inquiry or rendered any finding on that said aspect. The learned tribunal faulted the department for not issuing notice to the police authorities or to the commercial tax investigating authorities and calling for a report. It was specifically noted that while dealing with the assessee's explanation to the show cause notice, the commissioner has not recorded any finding, rather shifted the onus on the assessee to prove the negative. The learned tribunal rightly held that the revenue has to first determine as to whether the bank accounts belong to the assessee, more particularly when he has been emphasizing that the accounts do not belong to him and he has lodged an FIR with the police authorities. This aspect has been ignored by the commissioner while exercising power under section 263 of the Act. Furthermore, more importantly, when the assessee filed the reply to the show cause notice, they had specifically pleaded that as against the assessment orders, appeals have been filed before the Commission of Income Tax within bracket appeals, and copy of the appeal memorandum was also annexed to the reply. In such circumstances, the commissioner could not have invoked the power under section 263 of the Act, as there is a complete bar when an appeal is pending against an order of assessment. That apart, we find that the department has not undertaken any exercise to determine as to whether who is the actual account holder and who owns the properties and who is conducting the trading business of such magnitude. That apart, all the issues which were subject matter of the 263 proceedings was pending at the relevant time before the Commission of Income Tax within bracket appeals. With this reasoning, the assessee's appeals were allowed by the tribunal. After the order passed by the learned tribunal, the appeal filed by the assessee before the Commission of Income Tax within bracket appeals has been allowed, and the said order has become final. Apart from that, the assessing officer reopened the assessment, and an assessment order was passed under section 147 of the Act, which was appealed against before the and the said appeal has also been allowed in favor of the assessee, and the department has not challenged the said order, and the same attained finality. Copy of the order passed by the appellate authority has been placed before us for consideration. Thus, we find that the learned tribunal was fully justified in allowing the assessee's appeals. At this juncture, we take note of the decision in the case of Srimati Renuka Philip versus Income Tax Officer, 2018 409 ITR 567 within bracket Madras. Wherein the court took into consideration clause C of explanation 1 to section 263 of the Act, wherein it is clearly stated that when an appeal is pending before the Commissioner, the exercise of jurisdiction under section 263 is barred. For all the above reasons, we find no grounds to interfere with the order passed by the learned tribunal. Accordingly, the appeal fails dismissed. The substantial questions of law are answered against the revenue. Yes. Next also same assessment.
Same assessment here will be 1617.
Then it can be a common order.
Common order.
Yes. Or separate order. Mr. Mitra will say separate.
No, they may have got a different issue if it is on a common order, if you lordship.
Separate order, except the assessment here and the 1617 and the tribunal's case number in the first.
1617. Well, the 1617 orders of the CIT have handed over.
I'm bored on my lordship.
Next.
Item number 10.
I'm appealing this matter.
I'm appealing for the domestic.
But this is second round of litigations, my lord. Initially, this matter has, my lord, came up with your lordship, and your lordship had found that, my lord, the ITAT, the tribunal, my lord, did not record anything, my lord, on the basis of which, my lord, the conclusions has been arrived. The relevant portions of my lord's order is appearing at page 43 to 44 of your lordship's brief. I'm placing the relevant portion that is actually, my lord, starting from the mid of that page. Your lordship had found.
No, in the second round they succeeded.
Second round, my lord, the tribunal, my lord, alleged to have, my lord, followed the procedures, my lord, which your lordship has directed. I'm placing that, my lord. It starts from the mid of that page. Page 43, your lordship found. The assessing officer has held that the assessee was a private limited company which cannot issue shares in the same manner in which public limited company does. And insofar as creditworthiness and share subscriptions is concerned, there must be positive evidence to show the nature and source of the resource of the share subscriptions, and if the assessee was serious enough to establish his case, it ought to have complied with the notices, letters issued by the assessing officer, and ought to have produced the directors of the subscribing companies before the assessing officer so that they could explain the source from which the share subscriptions was made. It is stated it is stated that there is no complaints either from the end of the assessee company or from the end of the alleged subscriber company. This finding recorded by the assessing official has affirmed by the CIT appeal. If required to be set aside by the learned tribunal, response have to be assigned. Therefore, we find that the conclusions arrived at by the learned tribunal in paragraph number 11 is insufficient to support its ultimate conclusion in allowing the assessee appeal. Therefore, we are of the view that the matter has to be remanded back to the tribunal for fresh consideration. So, my lord, this was my lord's directions. Now, thereafter, in pursuance to that directions, my lord, the tribunal had actually, my lord, exercised a fact-finding mechanism and, my lord, have recorded certain facts. That's why I'm placing before lordship. That the relevant portion starts from page number 56 of your lordship's page. That's of a tribunal's order. Ideally, my lord, do not intend to, my lord, the compare, my lord, the earlier tribunal's order and that one, because from that page, which, my lord, I'm trying to indicate to your lordship, the tribunal have, my lord, discussed, I must be very candid, and elaborate aspects of that matter, which was, my lord, found missing in the earlier order. So, my lord, tribunal had, my lord, gone on to hold the identity aspect with regard to the fact that, my lord, the name of this company has been found in the MCA portal.
Creditworthiness, genuineness of
Yes,
transaction.
that creditworthiness part, my lord, there is an elaborate explanations, but the identity that
From that, in reply to the notice under 133(6),
my lord.
So, details of all the companies have been furnished, including confirmation letters. There is also a chartered accountant certificate.
Yes, those are there, my lord. Those are there.
Please come. This appeal by the revenue under section 260 cap A of the Income Tax Act 1961 within bracket the Act is directed against the order dated October 16, 2024, passed by the Income Tax Appellate Tribunal A Bench Kolkata within bracket Tribunal in ITA number 473/K1/2019 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. Question number A, page 5. Page 6, question C. E, F. That's enough. You have heard sounds. The assessee, the revenue is agreed by the impugned order passed by the learned tribunal, by which the appeal filed by the assessee filed by the assessee challenging the order passed by the Commission of Income Tax Appeals 9 Kolkata within bracket CATA dated 21/1/2019 was allowed. Earlier, the appeal was taken up for hearing by the learned tribunal and it was disposed of by order dated 23/2/2023. This order was put to challenge by the revenue before this court in IT number 36 of 2024, and the said appeal was allowed and allowed by judgment dated 10th April 2024, and the matter was remanded back to the tribunal for fresh consideration. Upon such remand, the tribunal has heard the matter and has allowed the assessee's appeal. Agreed by such order, the revenue has preferred the present appeal. The assessing officer had made addition under section 68 of the Act for alleged unexplained share capital and share premium received from 5 share applicants. This order was affirmed by the CIT. The learned tribunal has undertaken a thorough fact-finding exercise. After noting the principles which were laid down by the Honorable Supreme Court in the decision in Kale Khan Mohammed Hanif versus CIT 1963 50 ITR 1 within bracket SC and Roshan D. Hatti versus CIT 1977 107 ITR 938. Page 53 it is there, citation. After noting the principles which were laid down by the Honorable Supreme Court in the aforementioned 2 decisions, the learned tribunal examined the facts and the details which were furnished by the assessee in respect of each of the 5 share applicant companies. The details and documents which were furnished have been noted in paragraph 11 of the impugned order. After considering the documents and details, the learned tribunal has recorded a factual finding that the identity of the share applicants, share applicant companies cannot be disputed. The next full stop. The next aspect which was examined was the credit worthiness of the share applicant companies, for which the learned tribunal perused the financial statement of all the 5 companies and found that all the 5 companies had sufficient funds and the amount which was invested in the purchase of shares was negligible compared to their credit worthiness. Therefore, the tribunal was satisfied that satisfied about the credit worthiness of all the share applicant companies. While doing so, the tribunal also found that the identity of the share applicant companies and the genuineness of the transaction also cannot be disputed. Furthermore, the share applicant companies, in respect of the assessments made on the 5 share applicant companies, were all scrutiny assessments under section 143 within bracket 3 of the Act, and those remain intact. Furthermore, the source of share application money which has been received by the assessee has already been taxed in the hands of the share applicants, and therefore it was held taxing the same again in the hands of the assessee would tantamount to double addition. In this regard, reference was made to the decision of the Honorable Supreme Court in Mahavir Kumar Jain. Citation once. Mahavir Kumar Jain was a CIT. AAR online 2018 SC 1461. That apart, the learned tribunal also took note of the decision of this court in the case of PCIT versus Sri Leathers 2022 448 ITR 332. Thus we find, upon thorough examination of the factual position, the assessee's appeal was allowed by the learned tribunal. And we find no question of law, much less substantial question of law, arising for consideration. Then, for the above reasons, the appeal fails and is dismissed. Yes.
Matter item number 7.
I apologize, my lord and my lady.
You are for the respondent.
I'm for the respondent.
Roy Chaudhary.
So on last occasion, Mr. Bagh has taken time to take instruction. There is a little printing mistake in the appellate tribunal's order.
I've taken instruction.
What is the mistake?
The date, one date. Date is absolutely wrong. But that is in page.
At page 48, second paragraph, third line. Instead of 2021, it should be 2012. I've taken instruction. But I'll indicate that nothing on facts will turn on this. I'll indicate that.
Well, the issue is, after search and seizure, we find some indiscriminating materials. Well, on the basis of that, the assessing officer added strong amount of money, which was rejected by the CIT appeal and also rejected by the appellate tribunal. Now, kindly see in the assessment order, that is in page 11. Kindly see, it's a search and seizure operation under section 130T of the Encounter conducted on such and such day. That is on 13/12/2014. The assessment order was passed on 31st of December 2016. Kindly see what is the search and seizure. The seized impound material marked as CG2, paragraph 3 I'm reading, page number 1 and page number 2 show that one such and such in cash handling long-term capital gain in the course of post-search investigation. It was found that the assessee booked bogus long-term capital gain in the assessment year such and such. Summons under such and such was also issued. Then, kindly come paragraph 6. As per section 26 AS, the assessee has received a rental income of 9 crores, commission income 73 lakhs, which the assessee stated wrongly filed TDS and contractual receipts such and such. Then kindly come to paragraph 7. The assessee claimed to have raised share capital of 8.99 crores in this year, apart from the group companies and directors related to the person. 8.37 crores was claimed to have received on such and such amount. These included 2 companies. Then, Messrs. Bongshidhar Wincom Private Limited, Messrs. Cobra Tradecom. These indiscriminatory materials is a huge list in the assessment order. That was added to the tune of 2 crores, something odd, which was passed in favor of the revenue. Then, they prefer an appeal in the CIT appeal. The CIT appeal passed an order which is against us, and they subsequently.
But both the CIT appeals and the tribunal has recorded that There is no nexus between the alleged incriminating material.
That is wrong, my lord. What I'm
No, CIT appeals has given a factual finding. You please come to CIT appeals order.
well, kindly see there, both the CIT appeal and Income Tax Appellate Tribunal relied on 3 judgments. One is Kabul Chala of Delhi High Court, and one is
Fieldwell.
this particular court in Veer Prabhu Marketing and Salsa. Well, these are not at all relevant. Well, kindly see page 28.
See, the search was subsequent. No, by the time the assessments were all complete.
No, my lord, assessment was done after that. Assessment was done after that. My lord, kindly see.
The CIT appeal says the first point to note is that all the assessments in the case of the appellant have been completed as on the date of search. In this connection, therefore, the ratio of several cases have been stated the same thing. In cases where all the assessments have been completed as on the date of search, no addition that is not based upon incriminating material found during the search can be made. That Veer Prabhu Marketing.
Well, just one point, very simple. The return was filed on 25th of September 2012.
On what date?
25th of September 2012. Then search and seizure was done on 23rd of December 2014.
When was the assessment completed?
And the assessment was completed in 2016.
No.
Well, kindly see, the assessment order was passed on 16. Kindly see the order. The assessment order was passed, Malat, kindly 31st of December 2016, page 11.
So, if you had some material as of 2014, you should have connected that with the assessee, and then you should have completed the assessment.
Well, what happens in page 11?
There is a factual finding.
Malad, kindly see in page 12. Kindly see, Malad, in page 12, paragraph 4. Accordingly, notice under section 153 was issued on 7th of October 2015 and served to the SSC. In response to the notice, the SSC filed return in 2016. Total income is minus 6 lakhs. Then, Malad, this is to mention that the SSC filed the original return, which is also minus 6 point something. Both the return is same, which is not possible.
But what the assessing officer said, that assessee has raised a share capital of about rupees 8.99 crores. And this information was already part of the books of accounts. Where is the question? Where is the incriminating material?
Kindly see, after that, my lord, after paragraph 7, kindly come to paragraph 7.3, 7.4. 7.4 is in page 15. The SSC claimed to have received 25 lakhs from such and such company is big building such and such. Then, Malat, kindly come once again in paragraph 7.5. Another show cause notice was made on such and such. It appears from the records that you have raised share capital is given table below. Malat, kindly see, they have raised share capital in the right hand column. This is the amount. During the course of such and seizure operation, under section 132 of the Income Tax Act 61, on such and such date, several incriminating documents were found with ID marks CG1, CG2, etc., which show that the share capitals were actually your unaccounted money duly routed through entire operators, cash deposit in some bank accounts, and thereafter to different bank accounts of not traceable persons. It actually comes from your company as share capital. As for example, rupees 8 lakhs was deposited in the bank account of such and such in HDFC bank account on such and such date. On the same date, the amount has been transferred to the account of Messrs. Ferissa Commercial Private Limited. An amount of 18 lakhs was transferred. So this is a huge long list. Then, Malad, it appears that you have received share capital rupees 24 lakhs in page 18 from the above company. in this assessment year. It is seen that you have never issued any dividend to the shareholders, but huge amount of share application, share investment in your company without any reason from the person who is actually nil business activities, but only paper companies being run by entry operators. During the course of surveying the offices of the entry operators, all of them have stated under oath that they are under maintaining those paper companies only for giving accommodation entry to the companies like you for commission for a few paise per 100 rupees and transferring unaccounted cash on of the parties like you through different layers of individuals, proprietorship business, companies, and at last to the actual such and such. In view of the above, you are requested to show cause why the claim of share capital claimed to have raised in the assessment year as above will not be added under section 668. It is seen that you have also received share capital of 89 point such and such lakhs from Amicus Real Estate Private Limited and such. But during the course of such an operation, incriminating document was found that which shows that cash of rupees 3.5 lakhs was deposited in the bank account of Mrs. Ambika Trading Company on such and such date. But these incriminating documents were found, and accordingly, the assessment officer added.
If you see the assessment order,
Yes.
the link is missing. You refer to the search, but what was seized during material was seized. You need to connect that with the SSC. That is what the CITA says. You please come to page 49. The tribunal has extracted the finding of the appellate authority in para 3. It says, let us take the addition related to the addition on account of disturbance in Form 26 AS with receipts declared by the appellant. AO has noted that the appellant earned rental income against which TDS was deducted. AO has made addition based upon the alleged discrepancy between 26 AS and the receipts are declared in the books. AO has not been able to bring on record any material by which it can be inferred that this information regarding 26 AS or the receipt of the appellant were not already there as part of regular books of the appellant based on which the original return had been filed. Nowhere it has been brought on record that this information was obtained as a consequence of search or during search. 153A, the mandate is that. That is why he has referred to several decisions. CITA's order is a very elaborate order. If you come to page
36 onwards, my lord.
36 onwards.
Grounds 1 and 2, my lord.
From page 37, they noted that Veera Prabhu marketing.
Yes, I've seen it.
Then PCIT versus Salsar stockbroking, Calcutta High Court.
They basically relied on three judgments: Kabul Chawla, Veer Prabhu, and Salsar. Veer Prabhu and Salsar is from Calcutta High Court, and Kabul Chawla is from Delhi. Kindly come to page 20.
Calcutta High Court has endorsed the view of Kabul Chawla.
Page 20 of the assessment order, paragraph 7 and point 8. In view of the facts and circumstances of the case, whenever sum is credited in the books of the SSC, the owners lies on the SSC company to prove these criteria: identity, creditworthiness, and genuineness. Under section 68, the owners is the SSCs to prove the three ingredients. They fail. Now in 7.10, as how to the owners can discharge would depend on the facts and circumstances in each case. Then, my lord, the SSC is a private limited company which cannot issue shares in the same manner which a public limited company is doing. Well, kindly see paragraph 7.10, paragraph fourth line. The SSC is a private limited company which cannot issue shares in the same manner as the public limited company does. It has to generally depend on the persons known as directors or shareholders directly or indirectly to buy shares. once the monies are received and shares are issued, it is not as if the shareholder and SSE company lose touch with each and other company. So the whole procedure is absolutely wrong, what they have done.
If it was a 147, he can render all this finding. It is 153A
Yes.
read with 143.3. So if you see 153A, items. Notwithstanding anything contained in 139, 147, 148, 149, 151, and 153, in the case of a person where a search is initiated under 132, or books of accounts, documents on assets or acquisition under 132A, but not so and so, issue notice to furnish him within such period. So you have to have material to invoke 153A. If it is a reopening, then you can say that you did not establish the creditworthiness, etc. The three genuineness of the transaction, the three aspects, then you can go into all those facts. But both the appellate authority and the tribunal have concurrently held on facts. Where is the question of now to reappreciate and
initially the return was filed in 2012.
correct?
Then they showed is a minus. Then the search was done in 2014.
Correct.
Then, my lord, we have given notice under section 143(2) in 2015. Then, my lord, 153 notice was given on 7th of October 2015. And assessment order was done, my lord, on 31st December. Prior to that, they filed a second return. That is also same as the previous one in 2012. And both are minus.
But the finding of the tribunal that assessing officer was not able to bring on record any material, that is correct. He has cited all the decisions, etc. He has gone one step further. First, he should satisfy the ingredients of 153A. Then only he can proceed on merits. How to get over these factual findings?
The first return, when it was filed in 2012, the return was minus 6 lakhs odd. When the search and seizure was done, after giving...
Now the search, what they said was, one G2G, he received cash under the head long-term capital gain. But the AO has not made any addition on that. That's what this CIT appeal says. The AO's page 1 and page 2 of the assessment order, which are the notings of the AO, show that one G2G received cash under the head long-term capital gain. AO has recorded subsequently that in the course of post-search investigation, it was found that the assessee booked bogus LTCG in the assessment year 12-13, but has not made any addition in this regard in the case of the present appellant. Therefore, this information from the seized material cannot be construed as incriminating material for the purpose of addition made in this order, that is with regard to share capital.
Well, kindly come to the assessment order in page 11, paragraph 3.
Yes.
The seized impounded materials marked as CG2, page 1 and page 2, show that one G2G has received cash in the head of long-term capital gain. In the course of post-search investigation, it was found the assessee booked bogus long-term capital gain in the assessment year 2012-13. Summons under section 131 of the Act was issued to Sunil Kumar Kayan and company at Lance Range such and such. Then Malad, he admitted in his statement.
But no addition was made, correct?
No addition was
No addition was made. That's the problem. If the addition was made based on this, linking this G to G and that cash or whatever it is, bogus LTCG with the assessee, it's fine. But the CIT appeals finds that no addition has been made on that ground. Further, he says, except for the above reference to a seized material, there is no reference to any form of seized material, much less incriminating material found in the impugned order while making the said addition with regard to share capital.
Just come to page 24 once. In the assessment order, paragraph 7.15. In the light of the facts of the case and aforesaid exposition of the legal position, the findings of the search and seizure operation, no explanation adduced by the SSC with regard to the identity and creditworthiness of the subscriber companies and genuineness of the transaction is not acceptable. I am of the opinion that the credit of rupees 8 crore 37 lakhs in the books of the SSC company is own money of the SSC company shown in the grab of share capital. Hence, the entire amount 8.37 of the share capital is being added as unexplained cash.
He can do so only if he finds some incriminating material to connect that addition. If that is absent, nothing can be done. See, there is also a difference between seized material and incriminating material. All seized material will not be incriminating. He has undoubtedly seized some documents, etc. Statement might have been recorded. Those documents might have been seized. But incriminating material should connect the assessee with that, whatever material has been recovered.
That's why, my lord, in the calculation, my lord, kindly see in page 24. The total income of the assessee is computed minus such and such. Then the total income as per return is 53 such and such. Then the total amount was calculated in like this way.
Yes, what do you say, sir?
My lord, I'll go by the order because my lord of CIT appeals, lordship has already gone through it, I know, my lord. Only this part because it was being indicated by my learned senior friend, page 46, last 5 lines, my lord. Because he was referring to the share capital part. It is not the case that the share capital or premium raised was not disclosed in the regular books of the appellant or was otherwise brought to light on account of search. The aforesaid additions made under section 68 towards bogus share capital and on account of alleged discrepancy between form 26As and the receipts declared by the appellant therefore cannot be sustained and are deleted. So the rest of the part, it says no incriminating, the link is missing. That's the factual finding, which has been mirrored again held by the tribunal.
All right, please come. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961 within bracket DI is directed against the order dated May 8, 2024 passed by the Income Tax Appellate Tribunal B Bench Calcutta in IT within bracket SS bracket close full stop A number 97/K1/2023 for the assessment year 2012-13. The revenue has raised the following substantial questions of law consideration. Question B, page 5, question B. They are all not questions of law, everything is factual. Then page 7, question G, H. That's enough, we have heard so and so. The revenue is agreed by the order passed by the learned tribunal dated 8/5/2024 by which the appeal filed by the revenue challenging the order passed by the Commission of Income Tax Appeals NFAC Delhi dated 28/4/2023 was dismissed. A search and seizure operation was conducted at the office premises of Cygnus Group of Companies on 23/12/2014, of which the assessee was also a part of the said search and seizure operation. Various documents belonging to various companies were seized. However, it is an admitted factual position that no incriminating material relating to the assessee company was found or seized. The assessing officer issued notice under section 153 capital A, for which the assessee submitted capital A, and in response to the same, the assessee filed its return of income and also brought to the notice of the assessing officer that since no incriminating material was found in the course of search or any unaccounted goods or material was found, the assessment cannot be made under section 153 capital A of the Act. The assessing officer opined that the assessee could not point out any incriminating document. No, sorry. The assessing officer opined that no explanation has been given by the assessee with regard to the identity and creditworthiness of the subscriber companies, and the genuineness of the transaction has not been established, and therefore the credit of rupees 8,37,00,000,000 in the books of the assessee is the own money of the assessee company shown to be share capital. Accordingly, he held that the entire sum of share capital has to be added back as unexplained credit in the books of the assessee company, and accordingly added the same to the total income under section 68 of the Act. The assessee preferred appeal as against the said assessment order. The CITA has elaborately examined the factual position, and after noting the various decisions of the high courts, including that of this court, including the decision of this court in PCIT versus Salsar Stockbroking Limited, ITAT number 264 of 2016, dated 24/8/2016, proceeded to examine the factual position. Firstly, it took up for consideration the addition on account of discrepancy in Form 26 capital A capital S with that of the receipts declared by the assessee. The assessing officer had made addition based upon the alleged discrepancy between 26 capital A, Form 26 capital A capital S, and the receipts as declared by the assessee in its books. On examining the documents and details, the CITA found that the assessing officer has not been able to bring on record any material by which it can be inferred that the information regarding Form 26AS or the receipts of the assessee were not already as part of the regular books of the assessee based on which the original return had been filed. The CITA faulted the assessing officer for not bringing on record any information as a consequence of search or during search. Accordingly, it held that the addition based on the information referred to by the assessing officer did not emanate from any incriminating material found during the search and therefore cannot be sustained. In respect of the second addition, on account of alleged bogus share capital, the assessing officer has referred to the seized/impounded material marked as capital C, capital G /2, page number 1 and page number 2, which according to the assessing officer shows that one G2G, JETU space JI, G2G received cash under the head of long-term capital gain. The assessing officer recorded that in the course of post-search investigation, it was found that the assessee booked bogus LTCG in the assessment year 2012-13. However, he has not made any addition in this regard and therefore the information from the seized material cannot be construed as incriminating material for the purpose of addition with regard to share capital. In the assessment order, further, the assessing officer has mentioned in his order that the assessee had raised share capital amounting to rupees 8.99 crore during the year under consideration and found that this information was already a part of regular books of accounts of the assessee at the time of filing their return and did not come into possession of the assessee as a consequence of search. Therefore, it was held that the addition was not made on the basis of any incriminating material found during the search. The learned tribunal, after noting the factual finding recorded by the CITA, on its part, re-examined the facts and concurred with the CITA to the effect that the assessing officer was not able to bring on record any material from which it can be inferred that the information regarding Form 26AS or the receipts of the assessee was not part of regular books of the assessee based on which the original return has been filed. After referring to the decision of the High Court of Delhi in the case of CIT versus Kabul Chawla, 2016 380 ITR 573 with the bracket Delhi, right? Held that in terms of section 153 capital A would come into play only where there is existence of incriminating material, and in the absence of any such material, incriminating material, the assessing officer could not have resorted to the power conferred under section 153 capital A of the Act. Thus, we find the matter to be entirely factual and no question of law, much less substantial question of law, arises for consideration. For the above reasons, the appeal feels dismissed.
One prayer, my lord. On 13th of April, when the delay was admitted, well, my name was somehow omitted.
13th of
April. 23rd April, sorry.
23rd.
23rd.
And then his name, 23rd.
Great.
I'm very deeply obliged, minutes.
The case is about reopening. The tribunal has held that the
it was a case of change of opinion by the assessing officer. And the reasons recorded by the assessing officer is vague. My lord, the reasons are at page 34.
Might be so, Lordship. Seventy-eight is 77 regular. 78 হবে। সময় নিতে বললাম।
There are two cases, two appeals.
Yes. IT 78, which my lord is looking at, that is, my lord, arises out of a, my lord, 263 order. There was
263.
no.
My lord, the second one is dependent on the reopening.
So, my lord, if I, my lord, indicate IT is 78, my lord.
No,
That is, my lord, arises out of, my lord, a 263 order.
IT 77 is against the.
This is with regard to 260.
No, this is 147.
147.
147.
147. The IT 78 is 262.
263. Eventually, my lord, both this order, my lord, 263 order was, my lord, assailed, and my lord, the regular assessment order, my lord, where, my lord, the CIT appeal, my lord, has actually confirmed the additions made by the assessment officer. That was also assailed, and by the same order, my lord, the tribunal had, my lord, disposed of both the challenge, my lord.
Where is the order which was passed after you submitted your reply to the notice? The assessing officer issued notice making certain allegations. You filed a return of income and also objected to the reopening.
We objected to the reopening. The CIT did not consider my objections, and that is what the tribunal has done. They are saying that the objections have not been disposed of. My lord will have a look at page
Not
37.
separately. That is a separate issue. If I will only indicate the reason on the basis of which tribunal has actually decided.
So far as 147 is concerned, the tribunal says that the information is vague.
Yes.
Rather, there is nothing to connect the assessee with the other two companies or three companies.
Yes.
That is the finding. But where does the tribunal say that the objections were not disposed of?
My lord will take page 37 of the ITAT order.
Para 7.
Yes. Para 7.
37, para 7.
Dispose the objection separately.
Okay.
Separately.
So that was with regard to the GCAN drive, sir. Now presently, whether that has to be formally differently disposed of or not, that is something which ITAT has taken note of.
Because that is what GCAN says.
Yes.
Because there is no other remedy available under the Act.
Well, this is my lord's own judgment.
So therefore, you need to dispose of that. And if he is aggrieved, he can approach the High Court by filing a writ petition.
Yes, now whether this point was actually before the CIT appeal or not, whether that the CIT appeal has got any occasion to deal with, whether that objection was not disposed of or not is something which may
But whether the CIT appeals, what is the finding?
They confirm the addition, not on. Yes, I'm placing that. The relevant portion starts from page 21 of your lordship's brief. CIT appeal. Prior to that, my lord may take a look at the ground that has been taken by the assessee before CIT appeal. That starts from page 16 of your lordship's brief. It was all with regard to non-compliance of the CBDT circular, the reasons of opening and everything. Possibly this ground, which has been find place in the order of the tribunal, did not features there.
My lord, that is page 17.9 and 10. All this ground is specifically there before the CIT. Page 17, ground number 9 and ground number 10. My lord, ground number 10 is on the objection part.
Yes, yes, in the speaking. I stand corrected, my lord. Speaking order on all the objections.
But then if
Try,
then the entire thing goes.
and
In fact, the tribunal need not have exerted itself to see whether there was a link between the two companies.
now, my lord, with regard to, my lord, establishing that link, my lord, whether reason to believe of reopening, reassessment, these are, my lord, now, my lord, well-founded propositions of law, as your lordship had also held that there has to have, my lord, some cause or justification of reopening. It cannot be, my lord, a conclusive facts on the face at the time of reopening that the facts are to be linked in a watertight manner. It is, my lord, just invitations to the assessee, my lord, to participate in the assessment procedures, and, my lord, the assessee is all along, my lord, have got the all liberty to, my lord, place all the.
CIT appeals did not decide.
That is, my lord, one aspect I can't improve because this is a separate order was required to be passed or not.
Findings এখানে আছে
But findings, my lord, if you
CIT appeals, my lord, finding is at page 25 on the issue of reopening.
Yes.
Paragraph I in the middle, my lord. Therefore, on next page, my lord, para J, the bottom. My lord, kindly come to page 27, paragraph K.
Now, this 263, whether he was sought to reopen the assessment under 143.3 or reassessment under 143.
Reassessment, yes.
Tribunal says it is under 143.
That's not right, my lord. It is a reassessment procedure.
So it is barred by time. Where are the reasons of show cause notice under 263?
That appears, my lord, in ITT 78.
No, it's here.
My lord, page 53. My lord, it is extracted, my lord. My lord, point 21, the 263 is extracted. My lord, may have a look at point 3. I therefore propose to revise the assessment order under section 143.3, which is time barred, which is, my lord, because that is passed in 2015. 16 December 2015 is the assessment order.
Yes.
My lord, it is extracted here. That is why the tribunal holds that it is
16th December
2015.
So he could have exercised power within what time?
And within 2 years.
So it will be 17. 15, 12, 2017.
Well, that part is also dealt by the ITAT in page 54.23.
Commissioner sought to revise the assessment order passed on 16/12/15.
And then as per subsection 2 of section 263, the revisional powers could be exercised within 2 years from the end of the financial year, in which the order sought to be revised was passed.
So he could have done so before 31st March 2018.
Yes.
Now, my lord, kindly turn to page paragraph number 26 of the tribunal, sir.
But it's very clear, sir. 143.3. That is out.
That's true, my lord. Kindly take the trouble to come into paragraph number 26 of the tribunal, sir.
Has not specified that the assessment order passed and is being sought to be revised. Whereas the notice issued under 263 clearly says it is 143.3.
So, my lord, here, my lord, it has been it is recorded that it is with regard to the proceeding under section 147 in that paragraph.
But nonetheless, the tribunal went ahead and saw whether that was also justified.
My lord, if
No, my lord, with regard to, my lord, the fact whether, my lord, the notice by which, my lord, this 263 jurisdiction has been exercised does not on the face of it disclose, my lord, the sections under which the notice was issued, my lord, those are curable defect. Those will not, my lord, make the entire, my lord, the proceedings to given a go by. That will not possibly, my lord, that may not happen.
my lord, if you kindly see the 263 order, my lord, that is another brief, my lord.
Please give IT 8078.
It will show, my lord, that the 263 was invoked in respect of the reopening.
147, my lord.
147, my lord. Because I clearly mentioned that page 23, my lord. The information was received, case was reopened. These things are mentioned.
So if the reassessment order goes,
yes, my lord, then it also
gone.
goes. Yes, yes. And my
And
lord,
reassessment order has to go for not following GK.
my lord, the CIT has appealed that the GK was followed, my lord, in one paragraph. I was showing, my lord.
Please show.
My lord. Page 28, my lord. My lord raised the question that how the CIT has dealt. Page 28, paragraph L.
Paragraph?
L, first paragraph.
Correct. Reasons have been given, but order has not been passed. His objections have not been disposed of.
My lord, the tribunal has said that the objections were not disposed of separately.
Obviously, it has. You take GK drive short judgment.
No. That is there.
And there are paragraph 5.4, my lord.
Actually, it says the duty cast upon the assessing officer is to decide the written objection given by the assessee to the proposed reopening and pass a speaking order. And if the order goes against the assessee has the liberty to challenge the order by filing a writ petition, as no alternative remedy has been provided under the provisions of the Income Tax Act.
Because at that point of time, 148A was not enforced, because this is with regard to that assessment here.
The assessing officer is bound to dispose of the same by passing a speaking
order.
In fact, that exercise need not have been done by the tribunal. Sir, please come. ITAT number 77 of 2025 and 78 of 2025. These appeals have been preferred by the revenue under section 260 capital A of the Income Tax Act 1961, within bracket the Act, challenging the common order dated August 22, 2024, passed by the Income Tax Appellate Tribunal A Bench, Kolkata, in ITA number 637/KOL/2024 and ITA number 1067 of /KOL/2024, both for the assessment year 2013-14. The revenue has raised the following substantial questions of law for consideration. Page number 5 and 6, 1 and 2, only 2 questions, both questions. We have heard also.
May I take your lordship's leave?
Yes. First, we take up for consideration ITA 77 of 2025, which has been filed against the order passed by the learned tribunal in ITA 637/K1/2024. They said the matter concerns the validity of the reopening of the assessment under section 147 of the Act. The tribunal has examined the factual position and applied the various legal precedents to the facts and granted relief to the assessee. We need not labor much to consider as to the correctness of the order passed by the tribunal on account of undisputed facts. The assessing officer issued notice under section 147 of the Act, and pursuant to which the assessee filed its return of income and also sought for the reasons for reopening. The reasons for reopening was furnished to the assessee, and the assessee submitted their objection. It is an undisputed fact that the objections were not disposed of by the assessing officer by passing a speaking order. This defect goes to the root of the matter, as the assessing officer failed to follow the mandate laid down by the Honorable Supreme Court in GK and Drive Shafts India Limited versus the Income Tax Officer and others. The Honorable Supreme Court held that when a notice under section 148 of the Act is issued, the proper course of action for the noticee is to file a return if he so desires, to seek for reasons for issuing notices. The assessing officer is bound to furnish reasons within a reasonable time, and on receipt of the reasons, the noticee is entitled to file objections to issuance of notice, and the assessing officer is bound to dispose of the same by passing a speaking order. If this procedure has not been followed, then the entire reassessment proceedings has to fail. The decision in GK and Drive Shafts India Limited was taken note of by this court in the case of Principal Commissioner of Income Tax versus Champalal Om Prakash, 2025-171 taxman.com 796 within bracket Calcutta. The learned tribunal, after entering a finding that the reopening was bad in law, had also examined the factual position and has held in favor of the assessee, stating that the information which has been furnished in the reasons for reopening does not link the assessee with the alleged information, with the said information, and therefore the reopening was bad in law. Thus, on both grounds, we fully agree with the view subscribed with the learned tribunal, and we find no grounds to interfere with the impugned order passed by the learned tribunal in ITA number 637/K1/2024. Para ITA number 1067/K1/2024 was filed by the assessee, challenging the order passed by the Principal Commissioner of Income Tax, Calcutta 2, dated within bracket PCIT, dated 30th March 2024, passed under section 263 of the Act. In the notice issued under section 263 of the Act, the PCIT proposed to revise the assessment order passed under section 143 within bracket 3 of the Act. The tribunal rightly took note of the limitation which has been prescribed under section 263 and found that assessment order passed under section 143 within bracket 3 was passed on 16/12/2015, and power under section 263 could have been invoked up to 31st March 2018. However, the notice under section 263 was issued on 22/2/2024, and which will clearly show that the action initiated by the PCIT under section 263 of the Act was time-barred. The learned tribunal, not stopping with that, has also examined the factual position and found that the PCIT sought to reopen the assessment only based on the information collected pursuant to the show cause notice dated 20th February 2020. And if information has been available with the assessing officer with the approval of the PCIT, and non-inclusion of such information in the reasons for reopening would indicate the assessing officer was satisfied that such information is not sufficient for reopening. In any event, the argument of the learned senior standing counsels for the appellant department is that the reopening of the assessment was the power under section 263 was invoked to revise the assessment passed under section 147 of the Act. However, from the show cause notice issued under section 263, it is evidently clear that what was sought to be revised is the assessment order under section 143 within bracket 3 and not 147, which reassessment order has been set aside by the tribunal in ITA number 637 of 20/KO1/2024, and the appeal filed by the department in ITA 77 of 2025 has been dismissed in the preceding paragraphs. Thus, for all the above reasons, we find that the order passed by the learned tribunal is just and proper and does not call for any interference. Accordingly, the appeals fail and they are dismissed. The substantial questions of law are answered against Sarah.
Item number 13.
But I'm appearing.
May please.
There's a case of accommodation entry. If your lordship will kindly see the CIT's order, my lord, starts as page 17. If your lordship will kindly come to paragraph 4 of page number 30, my lord. My lord, here CIT's observation. I have gone through the grounds of appeal and the statement submissions of the page number 30.
Yes.
Paragraph 4. I have gone through the grounds of appeal and statement of facts submission of the appellant on this facts of the case. The brief facts is that the appellant filed his return of income for the assessment 13/14 on such and such day, declaring a total income of rupees 1,67,000. The case was selected for scrutiny through CSS, and the assessment was completed under section 143 of the Act. Then, Lord, thereafter, the assessing officer received information from DDIT investigation, Kolkata, wide letter bearing such and such number, dated 5th of March 2019, that in relation to the investigation proceedings, in the case of Messrs. On Trust Agro Food Private Limited and related beneficiaries, it was found that the appellant, Mrs. Onkara Wincom Private Limited, had taken an accommodation entry and bought back its own unaccounted money to the tune of rupees 1,51 lakh such and such into regular books of accounts during the financial year 12/13. It was found that Mrs. On Trust Agro Private Limited, a trader broker in food grains, items had no business relations with this identity and had no match profile of the customer. The assessing officer conducted necessary inquiries after taking approval from PCID 4, Kolkata, by issuing notice under section 136. On verification of the bank account of Mrs. On-Trust Agro Foods Private Limited, it was gathered that the account bearing number such and such with Baranagar branch was opened on 14/5/2012. The transaction pattern shows that the accounts got credited mainly by transfer and cash deposits, and cash were deposited from different locations in the range of rupees 6,600 to 8.5 lakhs, followed by simultaneous transfer of funds. It was further found that the transactions with the appellant was shown in as a sale of shares of Mrs. Jagabandhu Traders Private Limited as per the database of the said company controlled by accommodation entry providers with the department of Mrs. Jagabandhu Traders Private Limited. It was found, it was reflected that as per the paper shell companies controlled by the entry operator Sri Vijay Kumar Gupta. On the basis of the information, the assessing officer initiated proceeding under section 147 of the Act, issued notice on 148 on 20th March 2020. In response to said notice, the appellant filed his return of income on 16/6/2020, declaring income at rupees 1,67,000. Thereafter, notices were issued on section 143(2) and 121 of the Act. It was issued to the assessee. All the documents were furnished. During the financial, the appellant company filed submissions on 2021 before the assessing officer, but the required details were not filed by the appellant. Raised objections to the issuance of notice under section 148. The assessing officer disposed of the objections filed by the appellant by later dated 6/9/2021. The appellant again required to submit the details by notice of section 142(1), but no reply was filed. Thereafter, reminder was sent on 14/9/2021, but in response to the appellant again filed a submission wherein he again raised same objections against the issuance of notice on 148 of the Act. The assessing officer completed the assessment under section 147, read with 114B, a total income of rupees 1,50 lakh, made addition of rupees 1,51 lakhs under section 68. The assessing officer treated the introduction of rupees 1,51 lakhs in the books of accounts from the On-Trust Agro Food Limited, which was found to be a dubious entity in the name of sale of shares of the shell company of Jagabandhu Private Limited as an unexpended cash credit. No, this was, and there were another ground at page number 32 that the assessing officer, the ground number 1, that on the facts and circumstances of the case, the AO has acted beyond the jurisdiction by issuing notice under section 148 Act after the expiry of 4 years from the end of the assessment year 13-14, since there was no failure on the part of the assessing to disclose truly fully the necessary facts. In this ground, the observation is that in the grounds of the appellant had challenged the issuance of notice on the ground that the notice cannot be issued after the expiry of 4 years from the end of the relevant assessment year. In the case where the assessment year, the assessment or under section 143 was the act was made unless there was a failure on the part of the assessee to truly disclose the material facts. The appellant relied various case laws. I find that the appellant had not disclosed the true facts in this case. It came to the notice of the department later on that the entry of rupees 1,51 lakhs in the name of sale of sale of shares of Mr. Jagabandhu Traders Private Limited was an accommodation entry from Mrs. On-Trust Agro Food Private Limited, which was a company involved in giving accommodation entries. Thus, the appellant had not disclosed the true facts. Therefore, this is the observation. And in this respect, if your lordship will kindly see the observation of CIT, the tribunal, that is, now, there are other, sorry, before that, there are other grounds also, my lord. If your lordship will kindly sees, my lord, ground number 6. Ground number 6 raised that in page number 34, my lord, ground number 5 and 6. My lord, sorry, my lord, page number 33, if your lordship will kindly sees, my lord, ground number 5.3, ground number 4. That on the facts and circumstances of the case, the AO erred in making any generalized inference based on the arbitrary assumptions without supporting with the circumstantial evidence. In this ground, the appellant had challenged the assessment order on the ground that the AO had informed formed a general inference based on arbitrary assumptions without supporting it with the circumstances evidence. It is in the present case, it is the apparent not filed any details required by the assessing officer with respect to the credit of rupees 1 crore 51 lakhs. But they have not filed. Therefore, he failed therefore he failed to the officer satisfactory explanations of the nature or source of the entity. Further, the reference was also further to the proviso section 68 was not been retrospective with, or the reference to the case of law in the Lovely Export Private Limited is not relevant in this case. Basis those were shown by before the CIT appeal. Issued is not the share application money, but the receipt of amount rupees 1 crore 51 lakhs from the company or Mrs. On Trust Agro Private Limited, which was found to be an accommodation entry provider. The appellant has not filed the complete details even during the appellate proceedings. Therefore, the grounds of appeal is not sustainable. Dismissed. But this is ground number 4. Now, my lord, ground number 5 is also, my lord, that whether the facts and circumstances of the case, the assessing officer was erred in arbitrarily disregarding the genuineness of the transaction without taking into the cognition of the documents submitted in the course of reassessment proceedings. The assessing officer has not brought on the material record to prove that the transactions in respect to the company was not genuine. It was found that the appellant has challenged the assessment order on the ground that the order has been passed without taking into cognizance the documents submitted during the course.
Where does the assessing officer say,
my lord,
that the assessee failed to fully and truly disclose all material necessary for the assessment?
My lord.
Then only he can, because
Yes,
it
yes,
was a 143(3).
Yes.
Their consistent case is that that has not been pointed out.
Yes.
What was and the CIT appeals also does not say so.
No. But only on the
he says that page 32.
My lord.
He says appellant relied on various case laws.
Yes.
I find that the appellant had not disclosed the true facts of the case.
Yes.
It came to the notice of the department so and so in the name of Jagadambu.
Yes.
Thus the appellant has not disclosed. He says that was disclosed in the 143(3). That is the main ground.
Yes. Lord, assessment order is cryptic. Lord, page number 12, Lordship will kindly see only regarding 143(3), only 2, 3. And inform, Lord.
Because in his ground 1,
yes,
they have said
yes,
there was no material on record to prove that the assessee had failed to disclose fully and truly any material fact necessary for assessment.
Yes.
Thus, the provisions of 147 cannot be invoked beyond a period of 4 years from the relevant assessment year in the absence of any non-disclosure of material facts. So you have to say which was the material fact he did not disclose, which has led to the reopening. That should be
the material fact, my lord, that is, my lord, subsequently on the basis of DDIT investigation was found that, my lord, on trust, my lord, there was an accommodation entry and the amount was coming to him and the amounts were going. That was the specific case, my lord, in the assessment order. Lordship will kindly see assessment page 12, my lord, that an information was received from the DDIT investigation Kolkata by letter such and such in relation to the investigating proceedings in the case of On Trust Agro Private Limited in relation to the beneficiaries that the SSC Onkara Wincom Limited had taken accommodation entry and brought back its unaccounted money to the tune of 151 into the regular books of accounts during the financial year 12-13. This exercise, if I may, that has not been done by the assessing officer, but this was on the basis of information which was received from the DDIT investigation. It was further brought to the notice that On Trust Agro Limited was found in the trade broker in the food grain and had found no business relations with the entity.
Please come to page 13.
13, yes.
Unnumbered para 3. They say as per ROC data, etc., etc.
Yes.
Well, that is with respect to On Trust. I am not On Trust. The entire reasons are with respect to On Trust. They are doubting my sale to On Trust and they are alleging me to be a beneficiary.
Yes.
I have disclosed in my returns, in my books of accounts, which was under scrutiny under 143. And my lord, in that paragraph only, my lord, in the middle, then they say the transaction with the assessee was also examined. My lord, then they say assessee has shown the transaction being sale proceeds of shares of Jagbandhu. They are admitting that I have shown the transaction.
But prior to that, in view
And next paragraph also, my lord, they have not alleged anything. But the last paragraph, they have just reiterated the conditions of
147.
in view of the aforesaid facts, the AO had reasons to believe.
Tribunal's
I mean,
finding-
tribunal's finding at page 39, para 7.
Yes. After hearing the rival contention, peruse the material document, we note that in the case of assessment was found framed 143 by order dated 8/9/2015. The reopening was made unnecessary 147 by issuing 148 notice on such and such. The AO received informations later such and such that the SSC is a beneficiary.
40.
Page 40.
Page 40. Yes.
Third line.
Yes.
However,
Yes.
this is
This is
the
not
fact.
the facts of present case.
We note that the assessee has fully disclosed all the facts in the return of income filed under 139(1) of the Act by disclosing the said money received of rupees 1.5 crores in the books of accounts and also reflecting in the return of income, and the case was also selected for scrutiny and the assessment was framed under wide order dated 8 September 2013 passed under 143(3) of the Act. Therefore, mere observations on the part of the AO that the reopening beyond 4 years is made under 147 of the Act because of the failure on the part of the assessee to disclose fully and truly all the material facts which is necessary for assessment. In our opinion, the assessee cannot be attributed with the failure responsible for the said escapement of income, as the assessee has made full disclosure in the return of income.
Yes.
But,
Sir, please come.
No.
This appeal filed by the revenue under section 260 capital A of Income Tax Act 1960 within bracket the Act is directed against order dated October 9, 2024 passed with Income Tax Appellate Tribunal C Bench Calcutta within bracket Tribunal in ITA number 834/KOL/2024 for the assessment year 2013-14. The revenue has raised the following substantial questions of law for consideration. Page 5, question A and B. Page 6, question D. Are this not required? The short issue, we have heard some. So the short issue which falls for consideration, whether the reopening of the assessment for the year under consideration by reassessment order dated 21/9/2021 was valid in law. The assessee was unsuccessful before the first appellate authority, namely the commission, namely the National Faceless Appeal Center within bracket NFAC, Delhi, by which the appellate authority, Delhi, as the assessee's appeal was dismissed by order dated 29/2/2024. The assessee carried the matter on appeal before the learned tribunal, and the appeal was allowed. And challenging the said order, the revenue has filed the present appeal. What is required to be seen in the incident case is whether the reopening of the assessment beyond a period of 4 years was validly done, or in other words, was there material to show that the assessee failed to fully and truly disclose all material facts necessary for the assessment. The learned tribunal examined the factual position and found that the assessee has fully disclosed all facts in its return of income filed under section 139 within bracket 1 of the Act by disclosing the money received, namely rupees 1,51,00,000,000 in the books of accounts and also reflecting in the return of income, and the said case was selected for scrutiny and assessment was framed by the order dated 8/8/2013 passed under section 143 of the Act. Upon perusal of the reasons for reopening, we find that the assessing officer has merely extracted the statutory provision, or in other words, the ingredients as contained in section 147 of the Act, and there is nothing to indicate as to the failure on the part of the assessee to fully and truly disclose all material facts which are necessary for the assessment. In support of such conclusion, the learned tribunal placed reliance on the decision of the Honorable Supreme Court in ACIT versus CEAT Limited, CEAT, 2023, 146 taxman.com, 108 within bracket, SC.
Yeah.
The tribunal also examined the correctness of the approval granted by the Principal Commissioner of Income Tax under Section 151 of the Act and found that it was granted in a mechanical manner, without due application of mind, and held the same to be bad in law. To support such conclusion, reliance was placed on the decision of the High Court of Delhi in the case of Principal Commissioner of Income Tax versus Pioneer Town Planners Private Limited, 2024, 65 ITR 356 within bracket Delhi. In the light of the above findings, we are of the clear view that no question of law, much less substantial question of law, arises for consideration in this appeal. Accordingly, appeal feels dismissed.
Grateful. I'm grateful.
14, they wanted adjournment.
Item number 15.
14 is adjourned. Mr. Kundalia wanted time. Item 15 and 16.
No time.
Where is Mr. Amit Sharma?
He is Parakunal courtroom number 5. But he is here, me.
Reopening, is it?
My lord, kindly take up the brief of 82 first. That order has been relied upon in the 81. My lord, the issue is that 140 notice was issued by one assessing officer. They were transferred to another assessee. On the request of the assessee, the case was transferred to the another jurisdictional officer. Earlier, assessing officer had issued notices.
He continued.
He continued from that. That is the case.
Whether he can do it.
Under section 127, my lord, is that.
In fact, we have decided this issue.
You know, the thing is that 124 and 127 both operate in a different field. They are relying on 127(4), where it says that you need not issue fresh notice. 127(4) says. That is a case where, my lord, 127 comes into play where for restructuring purpose, department is transferring the file. So to save those cases, there this provision has, subclause 4 has come up. But where under 124, my inherent jurisdiction was with A, but B has issued notice.
But the assessment was transferred at the instance of the assessee.
Because I objected to the jurisdiction. I said, you don't have jurisdiction. I was filing my returns with ITO Ward 24, 1 and ITO Ward 61, 4 issued. So I said, you don't have jurisdiction. Then he immediately accepted it and transferred it to another.
So the other officer should have issued fresh notice.
Because the other first officer did not have any jurisdiction. So how that can be rectified?
The notice is invalid.
That my lord has taken cognizance of.
If the first officer did not have jurisdiction, then the notice is not voidable. It is void.
No, but they had jurisdiction.
Then why did he transfer?
Why? Because assessee said, since I am a director of company, the company is being assessed by that.
He could have said,
on that ground, it was transferred, my lord. My lord, in this case, when the notice was issued, the assessee filed his return of income before that assessing officer.
But this is not a curable defect. No. 127(4) will not apply to this case. He objected to the jurisdiction of the officer 61, Ward 61, 4. That objection was sustained. It was shifted to ITO Ward 61, correct? 61. So what he should have done is issued notices 148, 143, 1, and then proceed. That's what Blue Moon. Blue Moon is the decision. No?
That 143(2) has to be issued. My lord has taken cognizance which was relied upon by the tribunal also. This is the decision, my lord, on same facts. I've enclosed the tribunal's order so that facts are very clear below this.
Identical case.
Absolutely. And my lord, this Allahabad High
The other appeal, that is also same.
Same. Common order has been passed.
For 2 assessment years.
For 2 assessment years, this order was relied.
Said that I will not accede to your request because this officer, I have jurisdiction. But once he has accepted that he doesn't have jurisdiction and he shifted it to the another officer, he has to start from point A. He can't do it midway.
My lord, subject to correction, my lord.
If it is being transferred, file is transferred under 127(4).
My lord, the reason for transfer was because not of the jurisdictional issue. Assessee had claimed that his company is being assessed by the.
No, his objection was that he gave a written objection.
You know, this compiling this paper book, 2-page paper book I had given to my learned friend. From there, it is very clear, my lord. Last page, last.
I also state, Your Honor, do not have jurisdiction over my case.
And I had all through been filing my return of income with ITO range 24. All through I'd been 10 years. And this on because department had objected, made some objection. So before tribunal, we had given this compilation, and they have taken cognizance of these papers that SSC had filed return with ITO 24, range 24. All through 10 years, I'd been filing. He is my jurisdictional officer.
So this ITO 6, Ward 6-1 falls within range 24.
No, ITO 6-1, there is another internal circular which says that if I am a director in a company, I will be assessed where I am a director. In the
company is assessed.
Where company is assessed. So I am not saying anything, but AO came to the conclusion that because I am a director, so he transferred it to that company range. But basic.
But the company was also filing returns in range 24.
No.
No.
Range 24 individual SSCs can file. But wrong AO 64 one had issued notice. I told him that you don't have my jurisdiction. Then what he did, he transferred the file, recommended the then 127 order has to come. Then file was transferred where I am a director, the company in which I am director, that jurisdiction, my file was transferred. So the basic fact remains that the AO who issued jurisdictional notices under 148, 143(2), he never had my jurisdiction. And that has been dealt with in this decision. And my lord, Allahabad High Court says 124 and 127, they operate in different fields. Though it was against the SSC had requested to, objected to transfer of file.
In fact, we have dealt with that in that, in a writ petition, intra-court appeal. He was former minister.
At page 16, for the proposition that 127(4) will not apply. CIT appeal has zeroed in on 127(4), and they have also in their grounds they are raising that 127(4) plea. But that will confine to only 127 transfer of file.
In fact, we dealt with this. He was a former chief minister, Mr.
Kamalnath case, my lord. Kamalnath case. That is on the transfer and centralization. That is with
in that, I think we discussed about 127 and 124.
My lord, if you kindly grant me time, I will produce that judgments. My lord, judgments is Kamalnath's case.
That was confirmed by Supreme
Yes, the single bench order, Justice Saraf's order was that was affirmed by my lord.
Mr. Singhvi appeared in that matter.
And my lord, Maxwell also says that interpretation has to be contextual. Any clause of a provision has to be read in the context in which that provision is appearing.
Sir, please come. This appeal by the revenue filed under section 260 capital A of Income Tax Act 1961 within bracket the Act is directed against the order dated May 3, 2024, passed with Income Tax Appellate Tribunal B Bench, Calcutta, in ITA number 638/KOL/2022 for the assessment year 2010-11. The revenue has raised the following substantial questions of law for consideration. Page 5 and 6, 1, 2, 3, heard so and so. The short issue which falls for consideration in the instant case is whether the assessment order passed under section 147 read with section 3 of the Act dated 11/12/2017 was passed by the officer having jurisdiction. The undisputed facts are that the assessee had filed a return of income with the Assistant Commissioner, range 24, Calcutta. However, notice under section 148 of the Act dated 31/3/2017 and section 143 within bracket 2 of the Act dated 6/7/2017 were issued by the Income Tax Officer, Ward -61 within bracket 4, Kolkata. The assessee filed an objection dated 25/8/2016 stating that the Income Tax Officer, Ward 61 within bracket 4 does not have jurisdiction over his case and objected to the issuance of the notices. The objection raised by the assessee was accepted and accordingly the case was transferred to the Income Tax Officer, Ward 6 within bracket 1. And the assessment was framed. The learned tribunal found that it is an admitted fact that notice under section 148 as well as under section 143 within bracket 2 were issued by the Income Tax Officer, Ward 61 within bracket 4, and no notice was issued by the Income Tax Officer, Ward 6 within bracket 1, Kolkata. In this regard, we take note of the decision in the case of PCIT versus Bhagyalakshmi Conclave Private Limited, 2022 within bracket 12 TMI 1514 within bracket Calcutta, which was Calcutta, wherein the appeal filed by the department was dismissed, upholding the order passed by the learned tribunal, which quashed the assessment proceedings on the ground of lack of jurisdiction. The facts of the case are identical, and therefore the decision in the case of Bhagyalakshmi Conclave Private Limited will squarely apply to the facts of the case on hand. Thus, the tribunal, having rightly taken note of the undisputed factual position and applied the legal principle, we find no grounds to interfere with the impugned order. In the absence of any question of law, much less substantial question of law, this appeal cannot be entertained. For the above reasons, the appeal stands dismissed. Both matters. Yes.
My lord, that Kamalna's judgment.
The residence also, I am not able to scroll.
But my lord, that is in respect of another issue, a different issue.
But we didn't deal with that.
No, that is centralization, my lord. After search and seizure, whether the opportunity will be given to the assessee or hearing or not. If the assessing office, if the hearing is given, can it be transferred to another assessing officer on
That
both.
was.
No, no.
Appellate side, daily list, serial number 1.
No, in this matter, my lord, the learned advocate Usha Mighty is appearing, she is online, my lord.
Only in this matter, I am appearing on behalf of the contemptants number 1 to 7.
But
Well, in terms of the order, we have already taken steps. Notice was issued, and kindly at least give me 3 weeks time. I will pass the rigid order. That is the direction.
And what was the time fixed for?
No, your lordship, in the year 2019, my lord, order was passed. After service of the contempt application, as per your lordship's order, our notice was served that on 8th of July, they will give an opportunity of hearing. My lord, let them file an affidavit, your lordship.
this is the
Report of affidavit, my lord, I shall file my objection.
this is the copy, my lord.
We are the new incumbent, my lord. We have served the notice only on 29th May 2020.
This affidavit
Not correct, my lord, 21. Since 21, they are in power.
No, wait, madam. They have produced a letter addressed to your client.
My lord.
Fixing the date of personal hearing on 8th of July.
My lord.
Please ask your client to attend the hearing.
Yes.
They will pass a speaking order.
Yes.
Then
Yeah, by this time, they have already committed contempt.
This order,
Madam, you did not take any steps to list the matter.
Yes, I have taken step, my lord, having determination, my lord, I mentioned this matter before the Honorable Justice, my lord, Division Man, presided over by the Honorable Justice Devanshu Basak, my lord, so many times, my lord, when the power is given to their lordships, my lord. I have taken step, my lord.
In 3 weeks time, I will pass this order.
Lord, your lordship kindly, my lord, keep it pending, my lord, let them pass order.
Yes, 2 weeks.
We have heard the learned advocates for the parties. The learned advocate, appearing for the respondent/alleged contemptor, submitted that hearing notice has been issued to the applicant, fixing the hearing on 8/7/2025 at 12 p.m. and assures the court that a recent and speaking order will be passed immediately after the hearing is concluded. Let such order be passed within a period of 2 weeks from 8/7/2025. List the matter after 2 weeks.
Yes.
I'll get to you, lordship. As you lord.
Affidavit of service is
Kindly keep it pending, my lord, I shall.
Yes.
I'll get to your lordship.
Service is filed in the court, will let be kept in the court.
Serial number? Yes, my lord. Deeply obliged.
Get to your lordship.
Madam, appearing for the applicant.
Appearing for the CIS, led by Mrs. Chandra Yalama.
Hmm.
On the last occasion, it was pointed out that the
Financial
contempt
benefits-
application is not maintainable. Since prior to the filing of the contempt application, the petitioner himself filed a CAN application. As such, contempt application is not maintainable.
You are filing an affidavit?
In respect of the CAN application.
But no report has been given there.
Pardon?
No report. The copies.
Already given.
The report regarding contempt.
Already, you go through the report.
My lord? Yes.
You go through the report.
I have gone through, my lord. This report I have gone through, my lord.
You have gone through.
My lord.
What is your submission?
My lord, submission is my lord. First, my lord, come to once again, my request, my lord, come to the operative portion of the judgment, my lord. That is page 17, paragraph 17 of the contempt application, my lord. Page 17, paragraph 17 of the
No. Prior to filing contempt application, you find CAN 4 of 2020.
Yes, my lord.
Yes,
What was the direction issued in that CAN?
Nothing.
So, wherein you have claimed you have not been paid the financial benefits.
My lord.
In paragraph 12 at page 4, they have given the statement. And ultimately they say you have been reinstated in service on 11/5/16, granted all financial and consequential benefits.
No, my lord. That is not true.
So therefore, you
my lord, come to their my report.
No, you are disputing the quantum means it's a separate cause of action.
No, my lord.
Yes,
they says we have complied. But their report says that has not been complied.
Which report?
This report.
No, it
yes.
says.
That's my kindly come to page 3, paragraph 11 of the report.
It a contempt. Page
3, paragraph 11 of the report, my lord. For all purposes, in the principles of no work, no pay. No payment is made.
Yes, on the principle of, see, that is.
How, my lord,
No, you challenge this order.
No, my lord, kindly, they are sitting in appeal about the judgment of honorable division bench. What the division bench, honorable division bench said, my lord, they gone to the Supreme Court dismissed their application.
See, the division bench said that the appellant should be restored in original position in service if he has not attained the aid of superannuation, and then all financial benefits should be given to him as if he was never terminated. So therefore, you, according to them, you can't apply the principle of no work, no pay.
My lord, that's my response, my lord.
You get instruction. You have heard so and so.
And my lord, meanwhile, my lord, kindly dispose of the contempt application.
No, we'll keep it pending. We have heard.
My lord, contempt is not
pursuant to the directions issued earlier. Written instructions given to the learned standing counsel for the respondent / alleged contemnants dated 17/6/2025 has been placed before us. In paragraph 11 of the said instruction, it has been stated that the intervening period from the date of removal from service with effect from 11/9/2003 within bracket AN to the date of reinstatement in service on 11/5/2016 within bracket AN was treated as qualifying service for all purpose other than back wages in the principle of no work, no pay. Wide order dated 1/7/2016. The learned advocate for the applicant submitted. We will adjourn. You hear this order. The learned advocate appearing for the applicant submitted that this order passed by the authority dated 1/7/2016 is in violation of the direction issued by the Honorable Division Bench in FMA 894 of 2006. The Honorable Division Bench, while allowing the applicant's appeal in FMA 894 of 2006 by judgment dated 16/7/2015, issued the following direction. Sir, please copy para 17. There's no page number. From the above direction, it is seen that all financial benefits should be given to the applicant as if he was never terminated within a time frame. Therefore, prima facie it is clear. Therefore, we are of the prima facie view. The principle of no work, no pay cannot be made applicable to the applicant's case. The learned advocate appearing for the respondent / alleged contemnant seeks time to get instruction in the matter.
My lord, kindly comes to page 5, my lord. Para 1. That order was passed as per the notification of the central government.
All right, you get instruction. Let us see. We can set aside that order. List the matter after 2 weeks.
And my lord, kindly record it that prior to filing the contempt application, CAN application was filed.
That we will deal with it, sir. We are going to have a hearing. Next.
Number 3.
Lord, item 3, I appear on behalf of the appellant. This is a contempt application appearing for the first time. Now, my lord, your lordships will kindly recall that this is a matter, my lord, I was a bench clerk. Charge sheet was issued on 4th of June 2014.
Yes.
No proceeding was initiated. In the gradation list, my name appears in item 1. Lordship delivered a judgment, directed me, my lord, to make a representation, praying for an order for regularization of service and to allow me to join service and to ensure that the salaries are given. The operative portion of my lord's order, my lord.
Can you serve notice on the ground pleader? Or
I can do it, my lord.
Because Mr. Sapan Kumar Datta appeared and Siddhartha
I will
Banerjee
do whatever my lord directs.
The learned advocate appearing for the applicant is directed to serve notice on Mr. Sapan Kumar Datta, learned additional ground pleader, who appeared for the state, and Mr. Siddhartha Banerjee, who appeared for the High Court administration in FMA 208 of 2025. List the matter next week.
Lord, may I just only indicate one thing? I will be serving a notice upon the learned government pleader.
We have named him additional ground pleader. It is easier. because he appeared in the appeal,
Yes,
he will get instruction.
very well. I will do that, my lord. I'm extremely grateful. Serial number 4.
Well, I'm for the petitioner, supplementary affidavit. Well, kindly come at page 166. The specific mandatory order passed by your lordship as operative part 173, paragraph 21, my lord.
Yes, we remember.
My lord.
Now what happened after?
Such demolition shall be completed. Mandatory shall be completed and report to this court on 19th, my lord. Still now, demolition is incomplete. It is going on.
Whether any appeal was preferred against?
My lord, review application was dismissed by lordship. They preferred appeal before the superior SLP. SLP was dismissed with observation confirming order passed by lordship on 30th April.
It just started, my lord. Even today, right now, I have a talk with my officer.
Well, contempt have already done.
The
Demolition is going on. Lordship kindly, I prepared a report. It's a status review. Lordship kindly sees.
My lord, but
kindly goes through the report.
Contempt has already been committed, my lord. That very
But even right now, my lord, the demolition work is going on. Lordship kindly sees the report. It's a very detailed report. But this was on 18th. This was on 18th June because the lordship directed the matter to April 19th. So I instructed them that whatever steps you have taken.
File an application for extension, my lord.
No, lordship will kindly consider. My lord, I have instructed them. You prepare a report. Whatever steps you have taken. Till 18th. It is on 18th. And right now, lordship takes it from me. My lord, I had a talk right now that the construction is going on. Lordship kindly sees this report, my lord. Lot of demolition work has already been done.
Supplementary affidavit.
Let the supplementary affidavit, the copy of the contempt be served upon me. Yes.
When was the SLP dismissed? On what?
30th April.
Yes, my lord, after, because there was a lordship's direction that police should vacate. It was infested.
And my
police vacated.
My lord's order was confirmed and it was.
Then we will adjourn the matter sine die. It will go out of the list. If you start. This person who is senior standing and.
My lord, kindly consider the second paragraph onwards.
You ask your engineer to file an affidavit. This is a contempt petition.
That will.
What steps were taken?
But these steps, I'll put it on affidavit.
Let me complete the sentence. From the time starts running from the date when the SLP was dismissed. All right. We will take it from the date on which you received the copy of the order of the Honorable Supreme. From that date onwards, till date, we will have to give all the dates and events, what steps were taken, how much time police took to evict, what are the steps taken by police, what is the assistance you have rendered, etc. You file an affidavit.
Very good. But in the meantime, the copy of the contempt and the supplement will be served upon us.
I will give
Let there be a direction.
A copy of the contempt application, as also the supplementary affidavit filed by the petitioner, be supplied to the learned advocate appearing for the Calcutta Municipal Corporation. It is the contempt application has been filed alleging willful disobedience of the order and direction issued in WPAP 288 of 2024 dated 23/2025. As against the said judgment, a review application was filed which was dismissed, and KMC also filed an appeal before the Honorable Supreme Court, which was also dismissed.
No, KMC did not file the review. Review was by a third party.
Third party review petition was dismissed.
Yes.
KMC filed an appeal before the Supreme.
No.
Third party.
Yes.
The third
From
party
the dismissal
filed an appeal to the Honorable Supreme Court, which has been dismissed, affirming the direction issued by this court. A report has been filed by the Executive Engineer within bracket C, Buildings Department, Branch Roman 9, KMC, dated 18/6/2025, wherein it has been stated that demolition work has already commenced. We direct the Executive Engineer C, Building so and so to file an affidavit, clearly mentioning as to all the steps which have been taken by KMC along with the police authorities after the dismissal of the special leave petition by the Honorable Supreme Court. Let advance copy of such affidavit be served on the learned advocate for the applicant. List the matter after 3 weeks. Along with the affidavit, photographs should be also enclosed.
Grateful, Lordship.
Serial number 5.
Lord, I appear for private respondent.
None appears for the
Lord, he's appearing. Lord.
You are appearing. Last occasion, nobody appeared.
Because suddenly the schedule was changed, my lord. That's why.
No problem.
My lord, just I draw your attention. Page 45, operative portion of the judgment and order passed by the commercial court. Thereafter, division bench, two judgment of the division bench. There will come to the point whether the, as per my latest judgment of the apex court, that if there is a constitutional bench judgment and if it is not considered, because in Lolita Kumari's case, Supreme Court said even a complaint is made, if it discloses cognizable offense, court has to register a case. Certain exceptions are there for preliminary inquiry. And here, my lord, there is a new tactic is there. The police sent a report to the concerned lawyer, and concerned lawyer placed that report before the court, and that report is devoid of all the provisions of the erstwhile CRPC, present BNS. My lord, there is a provision for registration of a case if cognizable offense is disclosed. Well, come to page 45 first.
And you are appearing for the private respondent. Who appears for the state?
Lord, Mr. Amal Kumar Sen appeared the time.
State is very good because it's very important. Yes, madam, because state is very important because if this fact,
whether state has been served.
Yes.
Anybody can appear.
They might fix tomorrow, then I will again subcopy.
No. We can, if your junior can inform Mr. Amal Kumar Sen.
Yes.
Huh? We have heard Mr. Chakraborty, learned advocate for the applicant, and Mr. Gopal Chandra Ghosh, learned advocate for the private respondent. It appears that the state has been served, but none appears for the state. We direct the learned advocate appearing for the applicant to inform Mr. Amal Kumar Sen, learned additional ground pleader, who had appeared for the state when the appeal was heard and disposed of. List the matter next week under the same caption.
Yes, madam. But what happened? My lord passed this order, but there is a. We are never raised in a civil dispute. It was responded and lost in all quarters.
Great.
Serial number 7.
What about 6?
Appearing at my instance.
6.
Appearing at my instance, my lord. The review on a very short conspectus needn't be troubled with the papers. I indicate. A public interest litigation is filed before your lordship alleging that I, who was already the private respondent, who is a fair price shop builder, ration card, has issued 4,000 fake ration cards. An impression is given that based on this PIL petitioner's application complaint, an investigation was conducted, and I was found to have issued these, and thereafter a penalty of 50,000 rupees has been levied. And therefore, in these facts, your lordship correctly passed the order that such a person actually does not deserve to be even a dealer. But one thing that was not shown to your lordship, my lord, and was not a part of the application also, is the order of this 4,000 regarding this 4,000 complaint. I'll just place that, and I won't place my argument any further. Kindly have a look at.
So that may kindly sees with a memo of review. It's an appeal in disguise. Kindly sees any of the grounds, my lord. Any of the grounds. Error apparent.
May I just place that?
Appeal in disguise.
Your lordship will kindly have a look at page 19 once of my Lord, Can 1 is a application for condonation of delay. Strictly in review, it doesn't lie, but out of sheer abundant caution, my juniors drafted it. In that, if your lordship looks at page 16, Can 1, which is my condonation delay application, according to him, there's a delay of 41 days. So we've asked for a condonation of that.
Can 1, page 19.
Page 19 is this order. Yes, and your lordship's order is at page 16.
If I may just place your lordship's order first, and then I'll place page 19 once, and I won't think I'll have to really. At page 16, 20th March 2025. The petitioner alleges that the 10th respondent, who is a MR dealer, has utilized 4,000 fake ration cards and swindled of the public distribution items. Since the representation did not revoke any response, the petitioner has filed. The subdivisional controller has addressed the joint letter dated so-and-so, dated 27th February 2025, from which it has seen that pursuant to the complaint which has been lodged by the petitioner, an inquiry was conducted and an order has been passed against the 10th respondent dated 21st February 2025 by imposing the penalty of ₹50,000. It is not clear as to whether any appeal has been filed to the appellate authority under so-and-so. Thus, it appears that some action has been taken against the respondent, and what appears to be true is that the fake ration cards have been issued. Lord, disregard the rest of it, because if paragraph 5 is correct, then the 6 onwards, it is absolutely correct. So I don't even want to venture beyond paragraph 5. My only duty is to show that this impression that your lordship was given may not be correct. Kindly turns over to page 19, Vinod.
Yes.
Because this was possibly, it was not a part of the records. This was probably not shown to your lordship also. I'll just show, Vinod. 21st February 20, whereas an inspection team at page 19, whereas an inspection team containing so-and-so on 18 December, on the basis of complaint lodged by this petitioner, the inquiry team conducted physical inquiry on 18th and 19th. The following irregularities were detected. It was found that the shop's opening and closing times were not displayed in the prescribed manner, which violates so-and-so. Stock shortage was found at the time of inspection and compared to EPOS balance combined. The feedback granted based on a 5-point feedback sheet, which covered aspects such as the distribution of PDS commodities, performance under Duare ration, issuance of transaction slips, and the quality of food grains. Out of 38 families of different Duare ration cluster area, 9 families expressed dissatisfaction with certain aspects as follows, which violate 16, 11, 13, 22, and 23. 4. The inquiry team also inquired on the basis of the list provided by the complaint. This is the petitioner again. During this process, they were able to reach 16 families, out of which 12 responded, provided statements regarding the identification and verification of the DRC members, as well as confirming their existence or non-existence. These 12 families confirmed the existence of 93 DRC members out of a total 118 DRC members, while 25 DRC members could not be identified, and concerned family said that they had not gotten food grain against those unidentified DRCs from the FPs. So basically, one person coming with one ration card, he has several other persons under the family. Some are mentioned, again, to them, I have not given the food grains. Please turn over, my lord, to page 20. Whereas a show cause notice was issued, whereas dealer submitted a reply, whereas FPS dealer were given an opportunity of being heard, whereas show cause notice and personal hearing submission, FPS dealer took the following pleas. Just gives it a cursory glance, my lord. And your lordship will look at D, because the rest are regarding those unidentified deactivated 25 DRCs. The alleged FPS dealer clarified that he had no involvement in issuing DRC, and he provided full entitlements to beneficiaries for all their families. Typically, one family member claims the full amount for the entire family, so he doesn't personally know all family members. He's also accused the complainant so-and-so making false allegations or to damage his reputation. The next 2 paragraphs I want to highlight. Considering the reply of show cause and personal hearing submission, it is concluded that all reply of the alleged dealer not fully satisfactory, especially reply against point 1 and 3. 1 is that I don't have a hoarding, and 3 is distribution. People are unhappy with the quality of food grains that I'm giving out. So grossly violated 16(1), 11, 13, 22, 23, and thereafter 50,000. Well, I have taken the liberty of compiling. Anoni. Lord, may I just unbelievable.
So that 4,000 is a wrong figure.
That's right. So 1611, may I just hand it over? I had requested
some written instructions.
He had the. I tell you what was now. Give me 2 minutes, my lord. Comes back to
So
your
if
lordship's order.
this was the allegation, then 50,000 penalty is reasonable.
And now what has happened?
No,
my
that
lord,
was
now
other observations have to be deleted.
that's right.
Like in
That
the
is what.
petition, my lord, they have
Because
given
what
the
has
number.
happened now, they have gone ahead.
It's wrong, no, sir.
No, can you see, my lord, page 17 of the writ petition? Page 17.
Writ petition is
Yes,
not.
Yes, it has not been.
they have given the number. Fake ration card numbers. So, writ petition fund is that?
But inquiry committee.
4,000, my lord, I don't know, my lord, 4,000.
That's why I said
but
that if I place
ration
those
card
two
numbers,
pages,
I
I
would
would have to
We
do
were
anything.
given to understand based on that list.
list
It's
is
a large
not
scale scam. And to leave your client off with a paltry amount as penalty, it's against public interest.
I
So
completely.
therefore, we were persuaded to.
That's
make
right.
that
Well,
observation.
which is why I said that if I show those 2 pages, I will not have to argue any further. Your lordship was given the mistaken impression that I have issued 4,000 fake ration cards. That was not the complaint also.
The
That was not
complaint was
found.
opening closing time not displayed. Quality is not up to
Quality
them.
is not. And if your lordship, अरे कहनो तुम्हें आने से
complaint speaks about 4,000 ration cards.
Lordship went by the complaint.
Yes,
Had gone by the complaint. This is a complaint.
Lordship went by the
Because-
representation.
This is the representation we have submitted.
We
by
had
the petition.
we had one order. So Lordship went vis-a-vis the both this.
All right. This review application.
Now, Milord, I do have Milord some other Milord Lordship. Thereafter, Milord, what happened? The Lordship Milord kindly sees paragraph 9 of your Lordship's order. There was some Milord mandate on us.
Yes.
Therefore, we direct the SDO to take action in terms of clause 5 of the control order. The authority should also examine the aspect from the criminal angle as to whether the 10th respondent has colluded with the other person and conspired to commit this illegality. And authority should not be satisfied with just passing an order. Thereafter, inquiry was conducted. Joint inquiry team was there. We found anomalies. Slapped show cause notice upon him. And this is what we have. He has received the show cause notice also. That was on Milord. That was on Milord. This is the latest report dated Milord 18 June 20. He has got the show cause report. He must be knowing that. 27th May was the show cause report slapped upon him. Milord, they were giving him that within 7 days you give us a reply. Only Milord, kindly Milord, have a look at.
He has cooperated with the inquiry.
I have given a reply.
At page 50.
This appears to be a separate thing, my lord.
Not separate.
But here your lordship's
So the
orders
same
being
anomalies
carried
were
out.
found.
No, the order has,
Anomalies were found.
No, again, my lord, I don't
order
want
has
to.
worked itself out. All we can clarify is, though in the complaint it was alleged that there are 4,000 fake ration cards, it turns out from the order dated so and so, the allegation seems to be incorrect. Nonetheless, the direction issued in the order at paragraph 9 has been complied with.
No, 9, my lord, 9. My lord, again, I'll make the same mistake, my lord. Let me have a look at what has been. But 9, your lordship will kindly see. Subdivisional controller to take action. The authority should also examine the aspect of criminal angle as to whether 10th respondent has colluded with other person and conspired to commit this illegality.
We didn't.
This your lordship will tone it down or whatever that your lordship deems fit. And the fact is that your lordship was invited to pass this order on a completely different.
This review application has been filed to review the judgment and order dated so and so. Dated 23/2025 WPAP 59 of 2024. The said public interest writ petition was filed alleging that the 10th respondent writ petition, who is the review applicant, who is a MR dealer, has utilized 4,000 fake ration cards and swindled public distribution items. The court took note of the fact that the subdivisional officer control, subdivisional control, within bracket F&S, Malda Sadar, had addressed the joint director within bracket law, Department of Food and Supplies, by communication dated 27/2/2025, from which it was seen that pursuant to the complaint lodged by the writ petitioner, an inquiry was conducted against the applicant/10th respondent, and an order has been passed on 21/2/2022, imposing penalty of rupees 50,000. Going by the allegation made by the petitioner that 4,000 fake ration cards were utilized by the applicant/10th respondent, this court made the following observation/direction. please quote paragraph 9 of our order. The learned advocate appearing for the applicant submitted that the order passed by the authority dated 21/2/2025. This is not earlier I said 2022. It should be 21/2/2025. Appears to have not been placed before this court, and there is no allegation that 4,000 fake ration cards were utilized. And reasons have been set out as to why fine penalty of 50,000 was imposed. As the authority was not satisfied with the explanation offered by the applicant/10th respondent in respect of two allegations, namely the opening and closing time of the shop was not displayed, and secondly, the feedback received from the people showed that many of them were not satisfied with the quality of the items which were distributed under the public distribution scheme. If such is the factual position, then it goes without saying that the other observations/directions as contained in paragraph 9 can be eschewed. However, at this juncture, we are unable to do so in the light of the fact that the direction issued in paragraph 9 above has been complied with by the authority, and a show cause notice has been issued authority, and an inquiry team was formed, and inquiry was conducted, and a show cause notice dated 27/5/2025 has been issued to the applicant/10th respondent. Therefore, all that we can observe is that the allegation that 4,000 fake ration cards were utilized appears to be factually incorrect.
No, Miller, there is an insinuation of that effect.
No, Miller, this is a separate thing.
Unidentified people who have died, their ration cards. In their name, commodity was taken. Where has it gone?
Not even the allegation against me.
Appears to be factually incorrect, but nonetheless, in the inquiry conducted, certain defaults committed by the applicant 10th respondent has come to light. However, we do not wish to express any opinion on that, since the matter is still at the show cause notice stage. The applicant/10th respondent is directed to cooperate with the authorities by submitting his reply within the time permitted, and
I've done that already.
When cooperate with the inquiry, the authorities, as the applicant has already submitted his reply to the show cause notice, and after affording an opportunity of personal hearing, the authority, namely the subdivisional controller F&S Malda Sadar, shall pass a speaking order on merits and in accordance with law. With the above observation, the review application stands disposed.
Sir, I have only one request. Your Lordship will clarify that they'll do this independent of any observation held by Your Lordship.
Needless to state that the authority shall proceed in an independent manner based on the facts and figures which have emanated pursuant to the inquiry, and after considering the reply submitted by the applicant/10th respondent without in any manner being influenced by the observations made.
I am very
good. Judgment dated so and so in MAT number so and so.
No, there were two cans.
WPAP.
Everything can be disposed of.
There were two cans, my lord. Both interlocutory applications.
One was for condemnation of delay.
Condemnation of delay control. Thank you. Next.
Very grateful.
3:30, no? Today.
Number 7.
Lordship, this is an application against the rejection of my application for restoration of the order for dismissal of default before the tribunal. The original application before the tribunal was filed by Bokaro JP Cement Limited. that subsequently got merged with Dalmia Cement Bharat Limited. Before they could apply for substitution of parties before the tribunal, the case was dismissed for default. I applied for condonation of for restoration of the case, Lordship. That the Honorable Tribunal held that that was not the application was not proper. It was not authorized by the company. It was not signed by the company. Although on all those grounds, it was rejected. Sufficient details were not given in the application. I rectified my application and submitted a prayer for condonation of delay for restoration a second time, along with the prayer for condonation of delay. That also the tribunal has rejected on the ground that the second set of applications are not maintainable on grounds analogous to res judicata. These were not final orders, Lordship. These were all dismissal orders. So, to my mind, according to Section 11,
when was the merger? When did the merger take
Lordship, it took some time in 2018.
2018. This application was filed in 2013.
Lordship.
It was pending.
It was pending, Lordship, because for tribunal did not function for a very long time because of COVID and non-presence of a technical member. For quite some time, tribunal was not in session, Lordship.
And what was the order which was put to challenge before the tribunal?
That was with regard to some waybill, Lordship. Waybill was not taken. That was the penalty matter. Penalty of 45 lakhs had been imposed, against which we had given a security of rupees 13 lakhs. And thereafter, exchange of affidavits was directed, which had taken place, but the case did not come up for hearing, final hearing. It came, unfortunately, on 1st December 2023.
After how many years it came?
It was filed in 2012, Lordship. 13, Lordship, and after 10 years, Lordship.
10 years.
It came after 10 years, Lordship. On that particular day, Lordship, I had a personal disability because of expiry of my cousin brother, Lordship. I could not appear on that particular day. On that date, it was dismissed for default, Lordship. Kindly look at the order, Lordship, which is at page 31.
You please show the senior joint commissioner's order.
Lordship.
You had challenged an order before the tribunal.
Lordship.
You show that order.
Lordship, I do not have that order here with me. I have the order passed by the tribunal, by the tribunal, Lordship. That is at page 93. At page 93,
not
Lordship.
The tribunal. The order passed by the authority,
Lordship,
which was challenged before the tribunal.
Lordship, that then I will have to seek time for production of that order.
You produce that.
Lordship. Lordship.
Penalty matter, V-way bill.
Kindly see page 93's order, my lord. I would have not made any submission, just kindly read my lord page 93. It's an elaborate order. That is the first order after dismissal when he filed a restoration application.
One thing, the tribunal's observation is correct, that your clerk cannot swear to an affidavit regarding change of management.
Lordship, I admit that, Lordship, there were some defects in that application, which I have subsequently rectified, Lordship.
Now, before the where is the application filed before the tribunal?
For restoration, Lordship?
No, original application.
Original application. Lordship, that also I have not, since I have challenged only these two, then I will seek leave, Lordship, to produce the
No, you
order of
produce
the
everything. You produce the assessment order.
Lordship.
No, penalty order.
Penalty order.
The show cause notice, reply, penalty order.
If it comes out with that original application, I think it all will be annexed in that original application.
Yes, yes.
We have heard so and so. The learned advocate for the petitioner is
I would-
directed to
Lordship.
file a compilation containing all relevant documents.
Lordship.
List next week.
In the meanwhile, Lordship, I will just submit a very interesting judgment of the Honorable Supreme Court, which says the tribunal does not have any power of dismissal by default.
My
Lordship.
lord is going for that penalty order.
Lordship, yes,
We
I am
will
just
see
submitting.
the-
The tribunal does not have any power of dismissal itself. I am grateful. Lordship.
On principle.
Lordship, is there any date being fixed?
Next week.
Kindly see paragraph 13, Lordship, of the judgment. The tribunal
But
also
this is
decided that-
analyzing the provisions of the Income Tax Act and the Sestat rules.
Lordship, right.
But in this tribunal, what is
This
the
tribunal, they are to decide, according to section 8, subsection 5, they are to decide the application, Lordship.
we will decide the correctness of the order passed by the authority.
The CPC is applicable subject to coercion in this particular case.
How much was the penalty?
45 lakhs, Lordship. Out of which we have deposited 13 lakhs. As a security
And
pursuant to the
admittedly, the vehicle did not have a e-waybill.
Lordship, waybill could not be generated because of some latches, because of some technical outrage in the system at that point of time. We have enclosed screenshot of the system not functioning at the relevant point of time. That when I submit the main,
When did you generate the bill?
that could be done only after about a day. I don't remember exactly, Lordship, after some time.
After 24 hours.
Could be, Lordship, could be. I'll have to check.
But not within 8 hours.
No, Lordship, perhaps not. Perhaps not.
You
within 8
filed the
hours.
compilation letter.
Lordship, I am grateful, Lordship.
We'll go 3:30.
My lord, I beg apology, my lord. My lord, item number 10 and 11, my lord. Tomorrow, my lord, I have difficult. I will appear circuit bench, my lord, physically. I am, my lord, paid. Next week, my lord, my lord. 10 and 11.
Serial 12. Same place.
GST.
No, Lordship, I am in Dhanbad tomorrow. So for some context.
Item number 10 and 11.
12. আরে ও জন্মদিন করে চলে যাচ্ছে মানে it is his birthday on Sunday, that's why he is leaving.
Lordship, serial number 8 also, Lordship, next week. Serial number 8 also. My friend advocate, Lordship, next week.
You make the compilation and give him.
Lordship.
17.